So good afternoon, everyone. Hello, I'm Jocelyn Kennedy, the Executive Director here at the Harvard Law School Library. Welcome to the Law School Library Faculty Book Talk series. We're super excited you're here. Today's talk is being recorded and will be posted to our YouTube channel in about a week. Check out our Scholarship at Law blog for more information about our recordings and future book talks. I want to thank Dean Manning for his generous support of these talks, and a really big thank you to our library team, Maya Bergamasco, Debbie Ginsberg, Teresa Knapp, Anna Martin, and Rachel Parker, who make these talks happen so seamlessly. We welcome your questions for our panelists and invite you to use the Q&A feature throughout the talk. We'll reserve some time at the end for our panel to engage with your questions. It's my pleasure to introduce Randall Kennedy, the Michael R. Klein Professor of Law at Harvard Law School, where he teaches courses on contracts, criminal law, and the regulation of race relations. And Martha Minow, the 300th anniversary university professor at Harvard Law School, where she has taught since 1981. Professor Minow served as dean of the law school between 2009 and 2017, and as the inaugural Morgan and Helen Chu Dean and Professor. These are two of the editors of the newly launched American Journal of Law and Equality, which is what we're here to talk about today. We're delighted to have Professor Kennedy and Professor Minow with us as we celebrate this inaugural issue. I'll turn it over to you. Thanks so much for being here with us.
Thank you. Thank you to Jocelyn and to the entire amazing library team. You have kept us sane and learning all during the pandemic and before, and we count on after. We're just delighted to be able to talk today about this brand new journal. We've recently released the very first issue, and I'll just tell a little bit about the origin and then turn to my esteemed colleague, Professor Kennedy, for his reflections as well. You know, we've been through quite a challenging time the last year and a half, 2 years. And it really was in the wake of the George Floyd killing and the reckoning that really summoned in America about the unfinished journey on racial equality and racial oppression that I think triggered a phone call to me from Cass Sunstein, our fellow editor. And he said, we have to do something. How about, what do we do for a living? We are academics. We work on legal scholarship with the hope of informing policy and practice. Why don't we start a journal, a faculty edited journal? And I said, sure, how about getting Randy involved? And that's how it was born. So we're grateful to Cass. Sorry, he's not here today. He is serving in the Biden administration, so we excuse him. And he also played a role, not just in the idea, but even in contributing an article and some suggestions along the way, including negotiating the wonderful arrangement with MIT Press, which actually handles the publication of the journal. Equality is one of the words I hope we can talk about today. American is another. And with that, I'm going to turn it over to Randy Kennedy.
Well, thank you very much. And I too want to thank the library staff. The library staff's always wonderful in every season. And they've been helpful to this venture, like they are helpful to, frankly, any faculty member who calls upon the library will get a wonderful and enthusiastic response. And that certainly has been my experience. I think that's certainly been our experience with this journal. I remember getting the call from you, Martha, and it was at a very interesting moment. It was the George Floyd moment. There was a lot of disturbance in the air, anxiety in the air. It was quite clear that the administration of the law school wanted all of us to take note of this moment and do things that were in our kin that would try to address the moment. And so, you called me up and you said, well, what about a journal? And at that point, remember, we didn't have a title. We didn't have anything. We just had a feeling, really. There was this feeling, let's do something. And, you said, Cass had called you and you had agreed, and you all were going to do something. Will you join in doing something? And I said, yeah, sure. And then we started thinking of a journal, and we still did not have a title, but I think we all felt that I think we were attracted to the spirit of the moment, and we wanted to do something, and so we just decided to get in motion. And just one thing led to another. It wasn't until I think probably a month or two had gone by before we actually settled on a title, because at one point we had a title, but I remember you said, well, we'd gotten a little bit of pushback because there was some other journal that had a title that was very similar, and so we had to change. And my main point is, this is a project that we're still, it's by no means fully designed at all. We're still in motion. We're still thinking about what we want to do. But our main idea was, let's just get going and we will figure it out as we go. I did have one model in mind, I must say. One journal that stuck in my mind and that continues to stick in my mind as something of a model is the Supreme Court Review that comes out of the University of Chicago Law School. I've always been a fan of the Supreme Court Review, and I thought that what we had in mind was something like what the Supreme Court Review does.
Well, I'll pick it up from there and say, I guess it should be clear, but I'll underscore it. This is a faculty edited journal. And it is striking that actually in law, unlike just about every other field, the key journals that carry the scholarly work are student edited. And I'm a fan of student edited journals, and I'm grateful for being published in them. But there is something that we thought we could do with a faculty edited journal, and the Supreme Court Review is an example. That we could stimulate certain kinds of conversations that we think are insufficiently happening, both in terms of the subject matter, but also in terms of a kind of style of engagement, provocation, debate, discussion. And that is why we really, I think, planned and now have executed in the first issue a symposium. And maybe we can have the table of contents shared on the screen. So while, like any journal, we do seek submissions and get them through Scholastica, and we're delighted about that, we thought we could be proactive also. And to stimulate a debate and a discussion, Randy, I think it was your idea to have a symposium on Michael Sandel's then recently published book. I think it wasn't even quite out yet, The Tyranny of Merit. And quite specifically, to not just have one book review with one back and forth, but to have a variety of voices from different perspectives, different disciplines, different age groups, different demographic characteristics. So that's what we've done. So if you can actually slide down and see, there are 15 comments. Thanks very much on this important book, and Michael Sandel himself introduces the symposium with a summary of the book, and then offers a very careful point by point response. And we had a good question from Jocelyn as we were starting. Why did we decide to focus on this book about meritocracy? So, Professor Kennedy.
Well, the merit and meritocracy seemed to be in the air. It was the term meritocracy had obviously become a key word in political discourse, and certainly a key word in discourse about notions of equality. The year before, a professor at Yale, Markovits, who did contribute, by the way, to our symposium, he had written a big book that got a lot of attention. And then Michael Sandel, who is in the government department here at Harvard, but is also at the law school quite a lot, is taught at the law school, is very much a member of our community. He came out with a book that I knew would get a lot of attention. And so it seemed that this idea of meritocracy, the politics of meritocracy, the reaction against meritocracy, it seemed to be a burning issue, and one that attracted commentary from, all over the political spectrum. That's why I thought it would be a good center for a symposium.
And I think you were totally right. There was with alacrity, people joined in wanting to write their comments. And as we write in our introduction to the symposium, many people who are support equality have pointed to meritocracy and the use of kind of standardized tests as an example to overcome inherited status. But interestingly, meritocracy has come to mean many different things to different people. So if it once meant that people of skill and imagination can all aspire to succeeding, some people now talk about it in terms of domination by an influential class or subgroup. And that really does, I think, frame a lot of the debate. And we have points of view that I think range from, well, maybe we can improve meritocracy to let's trash the whole idea. And people also engaging with Michael Sandel's arguments, raising questions about specifically racial dimensions, gender dimensions, and also people raising questions about whether Michael's focus on really in the wake of the election of Donald Trump, a kind of despair and resentment by people who lack higher education and that's role in American politics. And that triggered, I think, a considerable amount of debate and discussion in the issue. Can we have the shared screen again just to look at the rest of the issue so you can see that in addition to this pretty substantial amount of pages devoted to the symposium, we actually have some articles, the editors contributed articles just to show that we're all in here. And Bill Alfred has a wonderful article that addresses key thinker in the contemporary philosophic world on equality and contrasts Peter Singer's views about global poverty with his views about disability. And then we also have a terrific exchange between our colleague Ben Idelson and Deborah Hellman, our alum who teaches at University of Virginia, on what we predict will be a growing area for discussion about equality and inequality, which is algorithmic practices and algorithmic decision-making and sorting. So that's the issue. And we were assisted in this effort with enormous grace and help by my assistant, Ellie Benet, and also by Brenda, who works for Cass Sunstein, and also by 4 outstanding and intrepid students who provided key reactions to the contributions as well as important editorial assistance. So that's the overview. One of the goals that we have is to explore different kinds of contributions. As much as we love and contribute to conventional law review writing, we wanted to explore less footnoted and more dialogic, more debating forms of discussion. And we are still exploring those possibilities for the next issue. I'm going to say that we want more than anything from this discussion to hear from people what your suggestions would be for future topics, for future contributors, for future formats. You know, one thought we even have is more cultural criticism, whether it's film reviews or reviews of websites. But I'll just say one more thing and then turn it again back to Professor Kennedy. We do see some important ambiguities in need of clarification in current legal and political discussions about equality. What do people proposing greater efforts to achieve equality really mean? What is it? Does it mean equality of opportunity, equality of results? Equality of what is one large theme. Another is how are there hidden features of the law that aren't so obvious in making equality difficult, in standing in the way of equality efforts. And one more is whether there are ways to advance the discussions about competing goals. On the one hand, equality, on the other hand, often pitted against equality is freedom. But there's also group-based analysis versus individual-based analysis. These are familiar features in the philosophic and legal discussions. Can we come up with some more productive ways to have these discussions? I noticed that the editorial pages of the Wall Street Journal today are filled with editorials about the risks of too much equality talk. This is an important subject that is dividing America. And we think in part, there's just not even agreement about what the terms of the debate are. Yeah. And we hope to illuminate that.
Couple things. I want to underline what Professor Minow just said about debate within the pages of the publication. I mean, one of the, like I said, we were sort of in motion thinking about things to do, but one thing that came up pretty early on and that we embraced, and I think we're going to continue to embrace, is the idea of dialogue in the pages. So at the very, our colleague, Professor Idelson and Professor Hellman, they end with an exchange. We begin with an exchange, the symposium. And even in the middle, we asked a couple of people for responses. So for instance, Bill Alford, I want to salute Bill Alford. He takes on this world famous philosopher on the philosopher's turf. And I wrote to Professor Singer and said, here's a draft. Yeah. We'd be very interested in your reaction. Now, he's a busy person. He decided, he didn't want to respond. Okay, fine. But we are going to, I think, going forward, systematically ask for responses and be open to responses. We want debate. and we want to be pretty open. So, for instance, on the question of equality, we're not only open to people who are thoroughgoing, in a thoroughgoing way, egalitarian. I'm very interested, for instance, in hearing from people who want to talk about maybe the vices of those who have been left behind. In the symposium, there's a lot of attention paid to the vices of the so-called winners. I mean, if you take a look at the Sandel Symposium, arrogance, hubris on the part of the winners, that's a very big subject, and people come at that subject in various ways. Well, what about the problem of envy? What about the problem of jealousy? What about the problem of resentment? We'd like to hear more from thoughtful commentators about those subjects. Now, those subjects have often, historically, those subjects have typically come from the rightwards end of the political spectrum. But, as far as I'm concerned, and I think I share this view with my colleagues, we're open. And not only are we open ideologically, we are open methodologically. We are open. There are a lot of law professors. There are people from other areas, and frankly, we're also open. And we say this very explicitly. We are academics. We are university people. This is, we elicit things from university people. But we think that there are people from all over in lots of different areas that have important things to say, and we're open to them as well. We're looking for knowledge. We're looking for insight wherever the insight can be found. And that's sort of the ethic that I think is behind our venture.
Oh, well said. And we're also this point about dialogue and debate. I personally love the format of a book review and an essay, but getting the author to respond after the essay is even better, so that the real engagement and, we hope, clarification. There are subjects we barely hint at in this first issue where we're eager to get more contributions, and I'll just name two. Criminal law is one, American Indian law and practice is another. But while it is a law journal, we actually are really interested in what happens in the world. And it's as much as I think we need clarification at the conceptual level, the true test is some connection to the world. So that's another feature. We're very grateful for those who are willing to take a gamble on a brand new journal. And so I understand Bill Alford is here. I don't know if Bill is willing to say something about his willingness to publish with us. Bill, are you willing?
Yes, indeed, Martha. Thank you so much. And thank you, Randy. I loved publishing with you. Martha gave me great comments. And I have to say, I can't imagine a better editor than Randy Kennedy. All the toughness and brilliance you see in his own writing comes through in his editing. He pushed and pushed in the very best way for me to be as fair and comprehensive about Peter Singer as I could be, to see things from Singer's viewpoint. And inspired by Randy, I went out and hired an advanced doctoral student in the Harvard Philosophy Department to, in effect, play the role of Peter Singer and push back again and again on me at any point. So I'm just immensely grateful, and I would encourage anyone to come forward and write for the journal, or do other things for the journal. It was just such a great experience. So thank you.
Wow, that is awesome. Thank you.
Thank you, Bill. I must say, when you sent your piece in, I was immediately admiring of your willingness to engage, such a important figure again on his turf. And I thought it showed a lot. It showed a certain intellectual adventurousness, and I really appreciated that. And I really appreciate your care and your response. You're absolutely right. I mean, you sent in the draft. I sent back, my candid responses. And let me say another thing about our theory of the journal and just our dealings with writers. And Professor Minow, jump in and correct me if you think I'm wrong, but my sense is one thing that's a bit distinctive about this journal is we view it as really a writer's journal. So people want, if we think that we want to publish something, we give our thoughts to the author. And by the way, we ask the small crew of students who work with us, we say to them, here's the piece. We want you to be very attentive readers. We want you to tell the author what you were thinking, everything that you're thinking, whether it's word choice, whether it's organization, whether you need more examples. No, you're going on too long with this. It's redundant. It's boring. Whatever you're thinking, let them know. But after that, it is the author's piece. And, in contrast to some journals, and again, it's a big world, and, I let pluralism reign. It's good that there are lots of different journals with lots of different ways of doing things. But we are not going to browbeat a writer. We're not going to try to grind anybody down. We give somebody the benefit of our thoughts, and then it's up to them. And if they don't want to take something, okay, fine, don't take it. And we publish the piece, but it really is the writer's piece. We view our editorial duty as to give somebody the benefit of our thoughts, and that's it. We have a very low overhead. There's not a whole lot of rules and regulations. It's not, there's not a whole lot of internal back and forth. We get the piece, we give it a thorough going over. Here's what we think. And then somebody writes back, and then our wonderful students, okay, let's go through it. Let's proof it. And that's it.
That's exactly right. And, in case it's not obvious, that means we're not checking footnotes. That also is the responsibility of the authors. And we just want to get good ideas out there. One more comment I guess I'll make about Bill Alford's piece. I think that the effort to draw a contrast between treatments of different kinds of people under the rubric of equality is an important effort that we hope to promote. So Bill's piece looks at the treatment of people with disabilities when compared with people who are impoverished. And I think one of the ways that we'll make some progress in understanding what equality does and could mean, and in critiquing what it has not meant, is by offering those kinds of comparisons. So I think we're just about ready to turn it over. If there's anyone here who has suggestions about new topics, questions about the journal, questions about the topics that we've raised here, we would be more than delighted to hear that. In the meantime, while we see if people have questions, we can say a word or two about the contributions that we gave. So, Professor Kennedy, tell us what you wrote about and why.
So I wrote a piece called Brown as Senior Citizen. And maybe there's a little bit of autobiographical thing going on there, because Brown versus Board of Education, of course, was announced on May 17, 1954. I was born on September 10, 1954. And so, this is a case that, it's my lifetime, so to speak. And in Brown as Senior Citizen, I really spoke to three propositions and wanted to respond to three propositions. One proposition: there are folks in legal academia who say that who suggest that Brown versus Board of Education didn't do a whole lot. And I react against that and say, no, Brown versus Board of Education is rightly seen as a landmark in American law and life. Before May 17th, 1954, it was legitimate. It was perfectly lawful for states like my home state of South Carolina to separate people in public primary and secondary schooling on racial grounds. You didn't have to hide it. You could be perfectly proud and, banner headline, this is what we do. And there was nothing wrong with it. After May 17, 1954, the legitimacy changed. The needle of legitimacy changed. After May 17th, 1954, officials could no longer legitimately do that. Did they do it? Yeah, they did it. But now they had to hide. Now they had to lie. Now they were on the defensive. And that has made a huge difference in American law and life. And so that was point one. Point two was, on the other hand, there's some people, including some of our mentors, Professor Minow, who think that, Brown versus Board of Education did it all. That it basically was a promise that, egalitarianism, at least racial egalitarianism, reigned in America. And no, that was pumping up Brown versus Board of Education too much. And so part of my essay is an effort to give a more realistic understanding of Brown in its historical context. Let's go back to 1954. Let's read what Chief Justice Warren said, and it's a much more limited, very important, but still limited holding than I think some people say. And then finally, my third was a critique of our current Supreme Court and its view of Brown versus Board of Education, which again wrenches Brown out of its historical context. Our current Supreme Court makes it seem as though efforts toward integration, if you use race, if you take race into account in order to try to create an integrated setting, the Chief Justice of the Supreme Court now says that's legally and morally the same as what was being condemned in Brown versus Board of Education, and I attack that. And so those are the three main points in my essay about Brown versus Board of Education in its elder years. What about you? What was your contribution?
Well, I first have to just say you're not a senior citizen, whatever we may think of Brown v. Board. It's a wonderful piece. I wrote something really to try to think through a puzzle that I would love to hear other people's thoughts about. And it really asking the question, why has equity, the word equity and what it may evoke, overtaken equality in contemporary discourse? In his first week in office, President Biden issued presidential orders about commitments to equity throughout the government. And I do explore, I don't think that I answer at all, how there are multiple possible meanings of equality. There are multiple possible meanings of equity. The abandonment of equality in a lot of contemporary discussions, indeed the dumping on equality, seems to me to throw the baby out with the bathwater, especially since American law embraces equal protection of the law, anti-discrimination, and not so much equity. But I try to explore the really two different meanings of equity that are at odds with each other. One is individualized treatment, distinct to each individual, a concept that's very dominant, for example, in religious free exercise and also in the area of disability rights in the school context. But compare that with systemic redress of group-based disadvantage. And those look like they're at odds, and yet the word equity is often used for both. In a field in which I have spent a lot of time, school reform, equity is all the rage. And there's a real contrast between those two meanings. And I argue that we should be much clearer without focusing so much on these words about what we're trying to accomplish and what we're trying to oppose. And when indeed we are seeking individualized accommodations and treatment, and when we are seeking systemic reforms and what it takes to do both. And again, not throw out equality as a framework, even if what we want is systemic reform, given the very serious work that Canadians have done on that score and that many people in the United States have done. But I am still struggling with this set of issues and would love some comments. I see that there are a couple of questions coming in, and I'll take one, which is the submissions process. The submissions process includes the online submission that is used now by many journals, the resource called Scholastica, and our librarians are fantastic at helping people figure out how to navigate the use of that. More informal inquiries can be directed to us, to the editors. But so those are the submissions processes, and we also solicit pieces as we did with the symposium. And I don't know, Professor Kennedy, do you have thoughts on the submissions process?
No, I think you've covered it.
Okay, good. And then there is a question about another topic. There's about limits of law in bringing about equality and role of private actors, such as corporate employers. That is such an important subject. I think both faces of it, the limits of the law and the role of private actors, I think we are keenly interested in both of those areas. And I would say they're touched on, particularly in the symposium on meritocracy, where private universities and private employers are very much a focus for many of the contributions. But I think there's much more that we could and should explore, including the downsides of relying on the government, but also the problems of relying on private actors. So I think those are really important issues. I very much like that the question includes promoting equity/social justice, which is right at the heartland of the issues that I was struggling with in my piece. What do we mean? And what words should we use? I also see a question here about whether we need another journal and whether we need an academic journal. If the issues of equality and inequality are as chronic and serious as I know that we both think they are, why a journal? And how would a journal help? And how would conversations in a journal ever enter the mainstream? Professor Kennedy.
I'm happy to take that on. I appreciate the question. And let me just, devil's advocate question. Do we need another academic journal as we think about equality issues? How do you see this journal helping to move society forward? How do you see the conversations in this journal entering the mainstream and being inclusive of lived experience? We are academics. We are ensconced in a great university. We have the benefits of the resources of a great university. And my idea is go to your strengths. I mean, I'm in a university. Why not use the forums, the resources that are available to me in a university? Now, if I was someplace else, I might use something else. But, why an academic journal? Because I'm an academic, and that's what I do. Now, how does this get out into the world? Well, it does get out into the world. Hundreds of students and others, but it's particularly students, pass through this law school every year. Hundreds. And rather quickly, they go out into the world. So, I mean, I'm just reading the newspaper, I'm listening to the radio, I'm watching TV, and I see somebody who, it seems like 15 minutes ago, was in class. And I was calling on Miss So-and-so, about some case, or talking with Miss So-and-so, in office hours about some idea. And now Miss So-and-so is in the government actually running things. Or, by the way, so-and-so, who was not, just a little while ago, it seems, was in class, is now Judge so-and-so. Well, and ruling on things, helping to shape law, using some of the very ideas that we talk about here. It's not as if these ideas don't go someplace. They do go places. These conversations, these articles, they stick in people's minds. And it's quite surprising, actually, where you find these ideas going. They do not stay put. So, I think that these debates that we have, these discussions that we have, it might look like they are just limited to Langdell Hall, but actually they're not. One last thing, and we really are very interested in hearing from people who might have ideas. To pick up on something Professor Minow said, I'll just tell you, in our next issue, there's going to be a symposium on the administration of criminal justice. We've asked a number of people to contribute. And the thing was really on our minds was something very practical, very much on the street. The issue of, on the one hand, the criticism that communities, especially minority communities, are over-policed. That's a urgent criticism. At the same time, at this very same time, there is a belief in many quarters that communities are underprotected by the law. And so we've asked people, some of whom have been very active in various protest movements, what about this? How should we see this? What do we say? If you were a mayoral candidate, if you were the mayor, if you were the chief of police, what do you do about this issue of, on the one hand, allegations of over-policing, and on the other hand, allegations of underprotection? What should we do? And by the way, when we ask people about this, one of the things we said, and this is sort of in the spirit of the questioner, one of the things we said is, listen, we're not looking for we're not looking for 100 pages. We are looking for pieces that people will read, and we really want them to be very direct, and the more particular, the more policy oriented, the more concrete, the better. And why did we say that? We said that because we want people to read this, and we want people to run with it and actually talk about it and bring these ideas to the attention of a wide range of people. By the way, I mean, among the people that we have asked or sought to get, comments from are people in law enforcement, for instance. So, in any event, that's my response to that question.
Oh, it's a great response. Randy and I both had the great privilege of working for Justice Thurgood Marshall, and Justice Marshall was asked, how did he want to be remembered? Mm-hmm. And he said he wanted to be remembered as he did what he could with what he had. And that is a phrase that I think about, I would say, every day. And am I doing what I can with what I have? We do have opportunity being academics, that we can choose what we work on. And being at Harvard, we have an opportunity to actually draw a little bit of the spotlight. Even the announcement of our creation of the journal received news stories. And then with the help of Dean Manning and Harvard Law School and the library, there's been tweeting and other kinds of contemporary communication. So we hope that the discussions that we help to promote actually get out to broader audiences and shift the conversation where necessary. Certainly draw attention. The power of agenda setting, political scientists tell us, is even more important than other kinds of power. And we view this as a small effort to set some agenda. I see another question about the intersection of technology, law, equality, and social justice, including algorithmic justice and data ethics in marginalized communities. Do we have thoughts or plans to explore the concepts and future issues? One reason we were so happy and excited to have the contribution of Professor Idelson in the very first issue was to absolutely plant that flag. One reason I teach in this area, I teach a course on fairness and privacy in perspectives from law and from computer science and statistics, is I think this is the new frontier. This is the new civil rights frontier. Our lives, all of our lives, whether we know it or not, are being subject to surveillance and orchestration by data analysis and by algorithms, whether it's in governmental agencies, police, for example. The deployment of where police go is increasingly organized by algorithms, or it's private actors, not just social media platforms, but brick and mortar companies are now all internet companies. Everybody's a data company. So there have been some explosive exposés about disturbing practices, particularly with the reliance on past data. Data is simply a way of describing how things have been. And if we have machine learning algorithms that learn to perfect how things have been, that is a way of instantiating, of solidifying.
Uh-oh.
Martha, you froze a little bit, so maybe we'll pause on Martha's contribution. And Randy, did you want to respond to that?
I was simply going to say that this question of technology will certainly be an ongoing concern of ours. One of the genomics, and then just the wide variety of new technologies will certainly be part of of this journal. So that, you know, I just want to emphasize what Martha was saying. Yeah.
Sorry about internet problems, and thanks. I see we have another question about how can students who are interested get involved with the journal. Just email us. Mm-hmm. That's the best way, and we're grateful for any interest. That's wonderful. And that, frankly, was one reason we had for being so glad that the library is willing to host this event, bring more attention and more engagement with the journal activities.
Well, let me butt in for a minute. You know, you mentioned Justice Marshall. One thing we should note is, you know, the first issue was dedicated to Justice Marshall. And Justice Marshall and his spirit, again, getting back to that earlier question, the devil's advocate question, and I think this really rubbed off. And, you know, now that I think about it, that's right. Cass Sunstein, clerk for Justice Marshall, you clerk for Justice Marshall, I clerk for Justice Marshall. Justice Marshall was, there's no justice who was more interested in notions of equality than Justice Marshall. And there was no one in American law who pushed harder for equality in various realms than Justice Marshall. And I would go further and say another quite distinctive thing about him, he was interested in the world of learning, true. He was also intensely practical. He was world to make things better. And I think that that is part of, you know, the governing ethos of this venture.
I'm so glad we had the chance to dedicate this first issue to him. You know, there are others who I hope we can honor in the future. And we certainly have been mindful of losing Justice Ginsburg this year. But yes, you know, Justice Marshall not only was Mr. Civil Rights before he joined the court, while on the court, he really attended to the situations of people. I think many people aren't aware that he paid attention to the situations of people, including older people, veterans, poor people, students. I mean, it really was his constant preoccupation.
Prisoners
for
prisoners,
sure.
yeah.
People on death row. Who is not getting a fair shake in America? And why is there a hierarchical arrangement of attention, consideration? His most powerful arguments really about poverty over and over again. So I agree with that very much, and I'm glad we had the chance to honor him. We've been asked, how do we see the journal in 10 or 20 years from now? I love the idea that it will still exist in 10 or 20 years. We will be looking for successor editors in that case, I have a feeling. I do think that the very fact that this is essentially an online, this is a digital journal. I'm old-fashioned, I had to print out a copy. I predict that we will see more uses of new technology tools to get the word out, to promote discussion. I can imagine a podcast. I can imagine other kinds of activities associated with the journal. And for that, of course, we would love comments and suggestions.
Mm-hmm. You know, legal scholarship is changing just like everything else is changing. And we are mindful of the need for change. And I think that one of the things about this venture is going to be that we're going to see we're going to see a wider range of subjects covered. I could imagine pieces about fiction. I could imagine pieces about movies, TV shows. Frankly, nothing is outside of our consideration, and we simply want to bring something together, writing that will illuminate the numberless issues that are generated by this very large, this very capacious word, equality.
We did include the adjective American to distinguish this journal from some others. I do think that comparisons with other countries are still on the table, but there is a distinctively American commitment to equality, at least equal opportunity, maybe other kinds of equality, and that is a focal point here. Having said that, I think that the old Aristotelian idea that treating likes alike is a core notion of equality, but treating those that are unlike differently is acceptable. That is where a lot of the pressure is, what's like and what's unlike. And we want to have more ways of understanding and challenging assumptions about that. So we're thankful to everyone who joined us here today. And again, for all who made this inaugural issue possible. You Google it, you'll find it. It's online. The American Journal of Law and Equality.
Thank you very much.
Thank you, professors, very much for joining us today. As Professor Minow said, you can get this from the journal from the MIT Press, and it's online. And thank you all of the listeners who joined us today. You can see this discussion in about a week when it's posted online. Our next book talk will also feature Professor Minow, and that will be Monday, November 8th from 12:30 to 1:30. It's on Saving the News by Martha Minow, featuring panelists from Harvard Law School, Professors Vicki C. Jackson and Nicholas Bowie. Thank you very much for coming today, and thank you for the entire library crew for keeping this going. We will see you in 2 weeks.
Bye-bye. Thank you.
Thanks so much.